Part 2, the mediation process. Mediation goals. Mediation helps you reach an agreement that's in the best interests of the children. We can help you work out the details of your parenting plan. Mediation is a great way to learn more about the other parent's point of view. Mediation helps parents focus on what works best for your children. What is discussed in mediation? A parenting plan that is in the best interest of your children. What is not discussed in mediation? Child support, spousal support, property, and other monetary disputes are not discussed in family court services mediation. A parenting plan may include timeshare schedule, that's when the children or child will be moving from one home to the other, a school year schedule, a summer schedule, holidays and birthdays that are important to you and your family, vacations, transportation and exchanges, phone calls, and extracurricular activities. Parenting plan considerations. Consider the age and emotional stage and development of each child. Plan for change as your children grow. Let your children know about schedule changes. Take into consideration your children's special needs. Let your children know when they will see their other parent. Legal custody may be discussed in your mediation. Legal custody includes the right to make decisions about a child's residence, health, education, and welfare. Legal custody is either joint or sole. Joint legal custody means that both parents have the right to make decisions equally. Sole legal custody means that one parent has the exclusive right to make decisions. Physical custody may be discussed in mediation as well. Physical custody is either joint or sole. Joint physical custody means both parents share significant periods of physical custody that assures frequent and continuing contact with both parents. Does not necessarily mean equal timeshare. One parent may still be designated as the primary caregiver for purposes of receiving public benefits. Sole physical custody is when one parent provides primary supervision and physical control or responsibility of the child or children. The other parent still retains rights of parenting time and visitation. What about custody when there's domestic violence? When there's been an act of domestic violence committed by a parent, the court presumes that they should not have the custody of the children. This presumption may be challenged at a court hearing regarding custody of your children. Domestic violence orders are handled outside of the mediation process. Mediation in Santa Clara County is non-recommending. This means that if there's no agreement reached, the following will occur. The matter will be referred back to court. The mediator will not discuss what happened during your sessions, and the mediator will not make a recommendation to the judge. Confidentiality exceptions. Mediation is confidential in Santa Clara County with the following exceptions. Mediators are permitted to recommend to the judge that an attorney be appointed for the child if appropriate. Mediators must report to the local child protection agency or law enforcement if they're concerned about abuse or neglect of children or a person's intent to kill. Mediation process. Sessions will be held separately if domestic violence is alleged, meaning that only one parent will be in the office with the mediator at a time. The parent who filed the current request usually goes first. Generally, the participants only include the legal parents and the mediator. Joint parties are expected to attend the mediation. Minors' counsel may attend the mediation sessions if he or she requests. Special rules when there's domestic violence. Restraining orders are obeyed at all times. The parties must wait for their mediation session on separate floors. Mediation will begin with separate sessions. A support person may be present during the mediation session. If you feel unsafe at any time, the mediator will end the joint session and interview both parents separately. Important points to keep in mind. Children do best when parents get along. Put aside your differences for your child's sake. Come to mediation with an open mind. Mediation guidelines. Do focus on your child's best interests. Come with an open mind. Prepare to discuss several possible options. Don't focus on the other parent. Reject a proposal without consideration, or let others make decisions for you. During mediation, each parent presents their proposals for child sharing and custody. Parents negotiate and compromise to reach an agreement. The mediator remains neutral, does not represent either side or take sides, helps both parties reach an agreement. Mediation outcomes. Full agreements are when the parents come to an entire agreement about all the disputes in their case. This agreement is prepared and signed by the mediator. It will be mailed to you for your approval and then forwarded to a judicial officer for endorsement. Partial agreements are when the parents resolve some of the disputes but not all of them. The parts that are agreed upon are prepared and signed by the mediator and sent to the parents for review and eventually to the judge for endorsement. The remaining issues still in dispute may return for additional mediation, or parents will be sent to the court for a judicial custody conference, or JCC, to talk about the remaining items that are not in agreement yet. Another outcome is no agreement. Should the parents not be able to come to any resolution, they'll receive a memo that'll give them directions on how to return to the court for a judicial custody conference to talk about those disputes. When a party is represented by an attorney, the agreement will also be submitted to the attorney for their review. Who are your mediators? Your mediators have master's degrees or higher in a behavioral science such as psychology, social work, marriage, family, or child counseling. They also have a minimum of 2 years experience and knowledge of the court system and community resources. Children in mediation. Mediators may use their discretion in deciding if your children will be interviewed. Mediators are trained to work sensitively in these matters. Children are not asked to choose sides or to choose between parents. Mediator limitations. Mediators may not discuss your case with judicial officers, attorneys, including your own, either parent alone outside of mediation. Mediators cannot give legal advice, discuss child support, spousal support, or division of property, or make recommendations to the court or decisions about the custody of your children. Frequently asked questions. How do I get my appointment? Family Court Services will send notice of your mediation appointment after both parties have completed orientation. When are appointments? Scheduled Monday through Friday for 120 minutes or 2 hours at either 9 or 1:30. What if someone fails to attend? Mediation will be rescheduled one time. 2 no-shows will result in a referral back to court. No-shows and late cancellations will have to pay a fee. How much does it cost? Mediation is free in Santa Clara County as long as you appear as scheduled. What if someone is late? Mediation cannot start until both parties arrive. A late arrival of 15 minutes may result in a reschedule of the appointment. More frequently asked questions. Who should attend? Both parents attend. Do not bring the children to your first appointment. Can I reschedule? Only in an emergency. Call 408-534 5760 to reschedule your appointment at least 48 hours in advance. Where is mediation held? Mediation sessions are held in the Family Court Services offices in Sunnyvale and San Jose.